Welcome to today's webinar. I'm going to be talking about how to preserve a client's public benefits that are needs-based. And this issue arises quite frequently because many clients who are disabled receive public benefits that can be impacted by the receipt of settlement proceeds. So it becomes quite an important issue. And one of the stumbling blocks at the outset is really understanding about the different public benefit programs, which ones are needs-based, which ones are not needs-based, and the type of planning that goes along with those. It's important to have somewhat of a background to issue spot. So the first part of the presentation is focused on that. So the needs-based public benefits are SSI and Medicaid. SSI stands for Supplemental Security Income, and it's a disability-based benefit that can be had by an injury victim if they become disabled and meet the eligibility tests for that particular program, which is based on financial need. Medicaid is the basic healthcare coverage afforded to people that are indigent and meet these financial eligibility tests. And there's a connection between SSI and Medicaid. So when somebody becomes eligible for SSI, they're going to automatically get Medicaid coverage. The entitlements are Social Security Disability, which is SSDI, and Medicare. SSDI is also a disability-based payment like SSI, except it's not based on financial need. It's based upon quarters worked. So in order to qualify for SSD, somebody has to have had enough work credits to become fully insured. And when they become eligible for SSD, if somebody becomes disabled, then they have access to Medicare prior to retirement age. So somebody can become disabled at any age and get Medicare coverage 24 months after they've received their first check for SSDI. So there's that connection between SSDI and Medicare. A couple other public benefits that come up are Section 8 housing programs and veteran benefits. Those can also be income and asset sensitive. But today I'm going to focus on SSI and Medicaid because the topic today has got to do with special needs trust, which is a planning mechanism utilized for these types of benefits. So with SSI, an easy way to tell whether a client is getting SSI as opposed to SSDI is by how much they're getting a month. The SSI benefit is limited to $733 a month if someone's single, or $1,100 a month if they're married. And with SSI, in order to qualify, you have to be below both an income cap and the asset cap. The asset cap is $2,000 if you're single and $3,000 if you're married. So it's quite low. And what that means is even a relatively small net settlement could push somebody over the asset cap and cause them to become ineligible for SSI. And then the Medicaid program, which is the basic healthcare coverage, is what most clients who are indigent are going to be left with. And there's many different Medicaid programs, and it varies state to state. But if it's related to SSI, then $1 of SSI in most states is automatically going to qualify a client for Medicaid. So just be aware of that connection between SSI and Medicaid because it's important to keep the client eligible for SSI if in fact they're going to need that Medicaid coverage down the line. So when you settle a case for someone that's disabled and they are receiving these types of public benefits, you have to make sure that an appropriate planning device is utilized. And if you have a client that's on Medicaid and or SSI is disabled, that's when you consider establishing a special needs trust. And the planning is necessary because when a case is settled, if you give the client the money, in that month, it's countable as income. And the very next month, if they haven't spent it all, it's an available resource. So either way, when you hand somebody a check, if it's more than $2,000 if they're single, or $3,000 if they're married, you have just destroyed their eligibility for SSI and Medicaid. Now, a lot of times clients don't care about the loss of SSI because it's a relatively small monthly amount, but the loss of Medicaid can be devastating and can be a huge problem if the client is in need of medical care that they can't otherwise pay for. So there are several different types of trusts that can be created for a personal injury settlement to avoid ruining eligibility when you settle a case for a disabled client. The first type of trust is authorized by 42 U.S.C. 1396P D4A, and we refer to that as a standalone special needs trust. And that can be created for a client that is disabled and under the age of 65. The second type of trust, which is becoming more commonly used for personal injury settlements, is a D4C pooled trust. And it's really identical to what we call a D4A standalone SNT, except it can be created for someone that's disabled of any age. There's no age restriction. The last one that comes up sometimes, not all that frequently, is a third-party special needs trust, which can be created in situations where the parents have assets and they want to leave those assets to a minor disabled child, and you settle the case and the minor's money goes into a D4A or D4C special needs trust because it's the minor's money, but the parents, when they pass, any assets that they have or any recovery that they might have would be countable to that minor child when it passes to the minor child. So in order to avoid that, you can set up a third-party special needs trust. Another situation where that can arise is where the community does a fundraiser for someone that's been seriously injured and that person is on Medicaid or SSI. The funds that have been raised, you would put into a third party, because the third party trust is for assets that are not the injury victim's own assets. So not a personal injury recovery. Those assets would go into a third party trust. So the special needs trust, the advantages of setting it up, it keeps the eligibility intact for the needs-based benefits. You have a professional trustee that manages the trust and can make sure that the financial affairs are kept in order and that the distributions from the trust are appropriate. In most situations, if somebody's a minor or incapacitated, it can avoid a guardianship in the annual reporting requirements, but that does vary state to state and varies by judge. And then these types of trusts can pay for everything except food and shelter. And the food and shelter restriction is because of the SSI benefit. So under federal law, the food and shelter must be paid for out of the SSI benefit. If the trust pays for it, it reduces the SSI benefit, so you don't want to do that. So the disadvantages of setting up this type of trust is that the use of the funds are restricted. It's a spendthrift trust. The trust monies can only be used for the sole benefit of the trust beneficiary, so you can't have a client who wants to give money to their kids or use the trust for other people, because that violates that sole benefit rule. At death, there's a Medicaid payback, and that's required under federal law. So when somebody passes, the trust has to pay back Medicaid for anything that Medicaid has paid for. And it varies state to state. Some do it from the date the trust is created until date of death, or it could encompass the entire lifetime. Putting one of these trusts into place is a bit more complex, and it is irrevocable. So it definitely is something that the client has to be sure that they are okay with in the end, because they don't have complete control over their financial affairs anymore. But the trade-off is they get to keep their public benefits, and if they need Medicaid or if they need the SSI benefit, then this is the only way to keep that intact, unless it's a smaller amount of money where potentially the money could be spent down in the same calendar month. That is an alternative to establishing a trust. But sometimes that's just not possible, or the amounts are too much. And so the trust is really an acceptable trade-off. One thing to be aware of is deeming. So what deeming means is that an amount of money is deemed between, say, a parent and their minor child, or a husband and wife. So if you have a personal injury case that involves a minor child who was injured at birth, and mom and dad have their own consortium claim, and you settle the case for the minor child, and for the consortium claims, the minor child's money goes into an SNT because the child is on Medicaid, but you give mom and dad money for their consortium claims, you've just disqualified that minor child because mom and dad's money is deemed to the minor child. So you have to be careful with that. Exempt assets are something else to be aware of. So the primary exempt assets are a house and a car. For many injury victims, that's a way to avoid setting up a special needs trust by purchasing exempt assets, because if they want to buy a house, they can buy that house. It's not countable. Same thing, they can buy a car as long as they have one car and it's for their transportation. So there are some ways to plan for an injury victim without setting up a trust if you have a client who's interested in just purchasing exempt assets. So I wanted to talk a little bit more about pooled trust because, as I said earlier in the presentation, they've become more frequently utilized in personal injury settlements because they're cheaper to set up. They operate identically. They're managed by a not-for-profit. So that means that you can set one up with a small amount of money, relatively small amount of money, and have a professional trustee and fiduciary. So because of that, that's some of the advantages of utilizing these types of trusts. And they're different from a standalone only in that there's no age restriction. So if you've got a client over 65 who has a personal injury settlement and needs to keep on public assistance, the only alternative is to set up a pooled trust. But because of the way pooled trusts are set up, the client is joining an already established master trust. They just have to create a joinder agreement, which is a legal document that elder law attorneys are familiar with, to join that already established trust. So it's quick and easy because you don't have to create a trust document from scratch. And in terms of the little kind of nitty-gritty issues as it relates to establishing trusts for people that are receiving a personal injury settlement and are on Medicaid, there's some FAQs, and these questions and answers will help highlight some of the ways that the trust can be used and who can set one up. The primary thing is that a client has to be disabled in order to join a pooled special needs trust. And the only reason they would establish it is to keep their public benefits intact. And in order to establish the trust sub-account, all they have to do is complete the joinder agreement I mentioned. And so it's quite simple to create. And the trust is simply funded by the personal injury settlement proceeds and can be augmented by other funds that the clients might have in order to liquidate assets and be eligible for their needs-based benefits. There's no minimum amount that has to go into the pooled trust. And if there is multiple settlements, you don't have to set up a new trust. Any future settlements can be added to the already established trust. And when the client needs money, they simply make a distribution request to use the monies inside of their trust account. The interest that's being earned on the trust corpus that is invested for their benefit is taxable, but usually that's a pretty small amount that winds up being taxable, and the trust can pay for the taxes. In terms of how monies can be used inside of a special needs trust, it really is anything that improves the quality of life for that beneficiary. but it has to be for their own sole benefit, and the trust is never going to be able to just distribute cash outright to the injury victim. But there's many things that the trust can pay for. It can pay for medical treatments that aren't already covered, experimental procedures, supplemental nursing care or attendant care, eyeglasses, dental, entertainment, case management, movies, training and educational programs, rehabilitative and occupational therapy, travel, companionship, cultural experiences, vacations, electronics, really pretty much nearly anything. It's not limited to just medical expenses. The primary thing is it can't pay for things that government assistance is already providing for the benefit of the injury victim. I wanted to talk briefly about a subset of personal injury victims that are what we call dual eligible, which means that they are Medicaid and Medicare eligible. And because they are eligible for both benefits, if it is a situation where a Medicare set-aside is being set up, there are some special considerations. But in terms of the different programs that somebody can be eligible for with dual eligibility, primarily what you've got is you've got Medicaid that's supplementing what Medicare provides. So Medicare becomes the primary payer when somebody is dual eligible, and Medicaid will pay some of the things that aren't paid for with Medicare. So it'll pay Part A and Part B premiums, deductibles, copays, and extra help with Part D costs. If they're what we call a QIMB, a qualified Medicare beneficiary, they're getting all those benefits. So somebody that's got Medicare and Medicaid in that scenario really has got zero out of pocket, so it's worth protecting. And because there are clients that are Medicare eligible for whom a Medicare set-aside may be set up, you have to understand that there are these solutions available to keep someone eligible for both, because a Medicare set-aside is considered an available resource for someone that's on Medicaid. So if you don't do extra planning and have that Medicare set-aside in a special needs trust wrapper, then the Medicare set-aside would cause disqualification. So the only difference between a special needs trust and a special needs trust that has a Medicare set-aside wrapped within it is that the SNT with the MSA has special language that dictates how the monies can be used. So in these scenarios, you would have two different trusts. You would have a trust established for just the monies that are for the special needs trust, and then you would have a separate amount allocated to the Medicare set-aside based upon an allocation report for the amount of future Medicare covered expenses. And the MSA SNT would pay only for Medicare covered expenses. The non-MSA SNT could pay for all the other things that I described earlier. So for clients that are dual eligible, you want to go that extra step and do the additional planning if a Medicare set-aside is going to be implemented. Although frequently, if the set-aside amount is small or relatively small, it may make sense not to set up a separate trust and simply have the Medicare set-aside housed within just a regular special needs trust, because there's no requirement necessarily to have an MSA SNT. It's just you can't have a set-aside outside of an SNT. So that may sound a bit complex. It really isn't. And in our practice of helping injury victims, we deal with these issues quite frequently and are well versed with it. So, because of these complicated issues that arise with trusts, the founders of Synergy created pooled trust services, which is a group of different trusts that can be utilized in personal injury settlements for a variety of different situations. So the first trust is the Settlement Solutions National Pooled Trust, or SSNPT for short, and that's a pooled special needs trust under D4C for those that are on Medicaid and SSI. As part of that trust, there is a subtrust that has a Medicare set-aside SNT. So for clients that are dual eligible, they would set up an extra sub-account with their Medicare set-aside. And then there's also a standalone trust just for Medicare set-asides for people that are not on Medicaid. And then there is a pooled settlement trust for those that are not qualified for any public benefits, just to manage their settlement proceeds. And then lastly, I had talked about the third-party trust. That is another type of trust that's available through the trust services component of what we do. So the trusts are established and managed by the Foundation for Those with Special Needs, Inc., which is a not-for-profit 501c3 that was created to help people with special needs and personal injury victims alike. And by supporting this trust with clients, it funds the foundation, which the foundation is committed to charitable organizations that protect and promote the civil justice system. So this trust is one that gives back to the system. A unique feature of the trust is its access to TrueLink Financial. TrueLink Financial is the asset manager and administrator of the funds. And as part of that, a TrueLink Visa card is made available to participants in the trust that they can use for general day-to-day expenses. Instead of having to make a written distribution request every time they need money, they've got a credit card that they have access to. And that's a really unique feature, because for most clients, if they have a trust in place, they're going to be dependent upon checks from the trust or written distribution requests, whereas our clients have access to the TrueLink card. In terms of the fees for the trust, it's amongst the lowest in the industry. The annual fee for the trust is 1.5%, and that includes the asset management fee. So that's the trustee fee and the asset management fee. Many of the trusts advertise their fees for trustee fees, and they could be quite low, but they hide the asset management fees, which can be 1.5%, 2% alone on top of their trustee fees. So you have to be careful about the fees. One thing too is that when you're evaluating different trusts, you really should evaluate what they do when a person passes away, because many pooled trusts retain all the assets if a person passes away. And so you have to be very careful about which trust is put into place for a client, because if they pass away suddenly and there is this 100% retention policy by the pooled trust, then the client's family might be upset that there is no money available to the heirs. With the pooled trust solutions, the only trust that has a retention is the pooled special needs trust, and it retains 10% or $10,000, whichever is less. Now, many trusts, as I said, will retain 50%, 100%. So you have to be very careful in evaluating these different types of solutions. One last point, there was a new option made available several years ago for people that have become disabled as an alternative to special needs trusts or as an add-on, and it's called ABLE. And these ABLE accounts are offered in nearly every state now. And if a client was disabled prior to age 26, they can establish this account, and up to $14,000 can be contributed to the plan. You can't put more than $100,000 in if you're on SSI, but it can be used to pay for food and shelter, unlike special needs trusts, but it does have a Medicaid payback. These types of accounts can be funded by a pooled special needs trust or a structured settlement. So as part of an overall plan, sometimes these accounts are helpful for the personal injury victim to get around some of the restrictions of a special needs trust. But it depends. Every case is different, and that's where, when you are working with professionals who are well-versed with these solutions, you can come up with a plan that ultimately is going to benefit the client as best as possible. So that's the end of the presentation in terms of the content. Just briefly, I wanted to tell you just about Synergy and what Synergy does. Synergy's focus is on all the issues that can make a settlement more complicated. And so instead of getting bogged down with these issues, you can refer them to us. We handle lien resolution, Medicare secondary payer compliance, settlement consulting and government benefit preservation, structured settlements, trust services through our pooled trust services, and tax deferral of contingent legal fees. If you have any questions about the presentation today, or have a question about a specific case that you need consultation regarding, my contact information is up on the screen now. You can email me at jason@synergysettlements.com or reach out via the phone or visit our website at synergysettlements.com. And I want to thank everybody's time and attention today. Hopefully this was informative for you. Thank you.